Turn the focus now to our annual fiduciary training, examining the Bagley-Keene Open Meeting Act and the conflict resolution issues, and will be led by Matt Jacobs, our general counsel. He'll be joined by Ashley Dunning and Amber Maltby, our outside fiduciary counsel. Mr. Jacobs, please get us started.
Yes, thank you, President Jones, and good afternoon to you and the board members. And welcome to the annual fiduciary training, which is mandated by the board governance policy. And as Henry just mentioned, in response to some requests from board members, the focus today will be on the Bagley-Keene Open Meeting Act and conflicts of interest, including the Political Reform Act and Government Code Section 1090. Your presenters, again, as Henry just mentioned, are a very able fiduciary counsel from the Nossman law firm, Ashley Dunning and Amber Maltby, and their impressive bios are provided in the agenda materials. I may interject with an occasional comment or question or clarification. And my colleague in the CalPERS legal office, Robert Carlin, who is our resident expert on many of the issues that our fiduciary counsel will be covering, is also standing by for any questions and comments that you may have. So with that, I will turn it over to Ashley, I think has got the first part of the presentation to get us started.
Thank you, Mr. Jacobs, and good afternoon, members of the board. Can you hear me well?
Yes, we
good.
can.
All right, thank you. As Mr. Jacobs mentioned, we will be presenting today your annual fiduciary training with our focus on the open meetings law that applies to CalPERS, as well as conflict of interest rules that apply to you both as well. And I'm very pleased to be joined today by my partner, Amber Maltby. If we could have the next slide, please. Amber is a partner in our government relations and regulation practice group at Nossman, and she does a lot of work in the conflict of interest field and advises on matters that are pertinent to what we'll be talking about today. Next slide, please. Slide 4, please. Okay, so whenever we talk about the laws and other rules that apply to the CalPERS board, we always start with the fiduciary framework within which you operate. Next slide, please. Slide 5, please. Thank you. And that is because it's important to view your legal obligations in terms of the open meeting laws and conflict of interest and otherwise within the framework of what you do, which is to administer the retirement plan and its investments. As you know well, the California Constitution vests you with plenary and sole and exclusive authority over those two aspects of the retirement system. And you're to carry out your responsibilities consistent with those duties, those fiduciary duties. And we've talked about that on other occasions in great depth. I've just encapsulated those parameters here with the 2 bullet points, noting that you are to act in good faith as a prudent expert in all the areas as to which you have jurisdiction, and you are to act in the overall best interest of retirement systems members and beneficiaries. As a board and as individual board members, you must therefore also comply with other applicable federal and state laws that apply to you. And there's a recitation here of the key framework for those laws: the California Constitution, the Pearl, of course. There are other California government law provisions that apply to you, including those that we're talking about today: Bagley-Keene's in the Government Code, the conflict of interest rules that apply to you as public officials are in the California Government Code, And then we have the recent California Supreme Court case that says, once again, you're to follow the statutes and other laws that apply to you as the governing board of the retirement system. Next slide, please. Moving now to focus on our first topic of the day, which is open meeting law compliance. Next slide, please. The basic parameters for having your meetings is the premise that unless an exception applies, CalPERS board and committee meetings must be open and public. So what does that mean? It means that before having what qualifies as a meeting, and we'll talk about what is a meeting, you need to provide sufficient notice to the public of the topics that will be addressed. And how do you do that? You do that through your agenda, through the timely posting of the agenda. The timing of that notice does depend upon what type of meeting you're having, a regular, special, or emergency. We'll talk about the specifics of those. And the agenda we'll talk about as well in terms of what needs to be on that agenda so as to provide sufficient notice to the public. Once you've had your notice duly published, then your meeting itself and your decisions need to be made in public. Again, unless an exception applies, unless you're allowed to meet in closed session on a particular topic, and we'll get into those specifics as well. The rationale here is that although some efficiencies are compromised by having to have your meetings and decision-making occur in public, the public is entitled to see that deliberation. And they also, while not authorized to participate in your actual meetings in terms of voting, they certainly are permitted to express their views through public comment, either on a matter within the jurisdiction of the board, on a general agenda item, or on particular agenda items that you have noticed for a particular meeting. Slide 8, please. First question then is, who has to comply with the Bagley-Keene open meetings law? This is the law that applies to state boards. Some of you I know are very involved with local public agencies, and so you may also be quite familiar with the Brown Act, which is the law that applies, the open meetings law that applies to local public agencies. There are lots of similarities between the Brown Act and Bagley-Keene. There are also important differences. Today, we're focusing on Bagley-Keene because that's the law that applies to CalPERS' board and committees. So one of the differences in terms of Bagley-Keene and the Brown Act is that the Bagley-Keene has somewhat different rules in terms of which types of committees the open meeting law applies to. And in Bagley-Keene, if two or more persons are on a subsidiary body or committee and exercise authority of the state body, they're considered a Bagley-Keene committee, a committee that needs to comply with the law just as the board does. Similarly, advisory bodies that meet the criteria set forth in these 3 bullet points. So if the advisory body is created by formal action of the state body or of any member of the state body, and it's composed of 3 or more persons, and multi-member bodies that are supported by agency funds in which board members are serving on that body in an official capacity, all of those criteria result in an advisory body being subject to the open meeting components of the Bagley-Keene Act. I welcome questions or comments, or if Robert, Carlin, you would like to weigh in on any of this, I welcome your comments, of course, as well. Next slide, please. Who does not need to comply? This is really important as well, because as I noted, there are efficiencies that obviously are compromised by proceeding with having all of your decision-making and deliberations need to occur in public. And you certainly don't want to trip over these rules. It's helpful, therefore, to understand that when a board chair or a committee chair, or maybe even an individual trustee is communicating with your executive staff or with your consultants, those are not meetings as defined by Bagley-Keene that would trigger the notice and agenda requirements. So long as, and this is a very important caveat, you don't have a serial meeting dynamic where that individual, either your CEO or somebody else on staff or even a general counsel, becomes a spoke in the wheel who's communicating to multiple members of the board or committee what the other people think. And that's what can't happen. You can have your communications to gain understanding, to provide your views, to explore topics, but not to get around the Bagley-Keene open meeting requirements. Next slide, please. What is a meeting then? It's a communication, so not limited to speaking or formal written communication. It can be as simple as an email or a text. Any communication among a quorum of the body, so among a quorum of the standing committee or board on a topic within the jurisdiction of the board or committee. So if you're talking about something that's completely unrelated to CalPERS or matters within the jurisdiction of CalPERS with the quorum of the board, you're talking about something social or perhaps even political that has nothing to do with CalPERS. That shouldn't be a problem. But once you're within the arena of talking about something within the jurisdiction of the board, say the assumed rate of return or an investment decision that the board might be considering, that there you're clearly within the jurisdiction of the board. And to the extent that any communication involves discussion, debate, or deliberation, you may well be engaging in what qualifies as a meeting. Next slide, please. Receiving, even in sort of a passive way, receiving information from your fellow trustees, processing and discussing information as a meeting. So what does this mean? It means that you can't have study sessions. This is very unusual for people who may be coming to a board as a public official for the first time, coming from the private sector, where you might be very much more accustomed to having to a board as a public official for the first time, coming from the private sector, where you might be very much more accustomed to having study sessions, pre-meeting briefings to be sure you completely understand what's happening, efforts to achieve a consensus among board members. That's just simply not permitted within a quorum of the board or committee, because that can constitute a Brown Act violation. I mean, a Bagley-Keene violation. Something that comes up with some regularity is where board or committee members have read something of great interest that they think the rest of the board would be valuable for the rest of the board to review, say, prior to making a decision on something. If the board member, perhaps very innocently, sends that communication around to the rest of the board, arguably there's a problem under Bagley-Keene, because you have more than a quorum of the board communicating with one another on a topic within the board's jurisdiction, outside of a properly noticed meeting. Next slide, please. Email has created an interesting challenge in the open meeting compliance world, particularly with the facility with which people can reply all. You may well have a perfectly compliant one-way communication from a staff member to the board about a topic. But if a member receives it and then responds reply all, seeking to say clarify the topic, perhaps even state their view in an attempt to reach an agreement or compromise or advance resolution, that creates a Brown Act, an open meeting law violation, either under Bagley-Keene or the Brown Act. Next slide, please. I've quoted some of the provisions of Bagley-Keene on this slide to bring home what I have been describing high level here in terms of how one might have a Bagley-Keene violation inadvertently. Because it states very clearly in this first bullet point that is reciting Government Code Section 11122.5, what you shall not do. And that is that the majority of the CalPERS board or committee shall not, outside of a meeting authorized by this chapter, use a series of communications of any kind. So i.e. email, text, phone calls, one-on-one, directly or through intermediaries. So having somebody else convey a message for you, to discuss, deliberate, or take action on any item of business that is within the subject matter of the state body. Again, it's not limited to the vote that's taken on a particular day, but it's any part of that deliberative process that precedes the vote, the discussion, the deliberation. That said, as I mentioned, there are discussions that you can have before meetings that do not violate Bagley-Keene, and that's set forth in subdivision B2 of this same statute within the government code. And it says paragraph 1 shall not be construed to prevent an employee or official of a state agency, so any of you, from engaging in separate conversations or communications outside of a meeting authorized by this chapter with members of a legislative body in order to answer questions or provide information regarding a matter that's within the subject matter jurisdiction of the state agency, if that person does not communicate to members of the legislative body the comments or positions of any other member or members of the legislative body. So you too may not be the spokes in the wheel that convey the views of one another to others outside of a duly noticed meeting. You can say what your views are, but not those of others. I see a question has come in. Trustee Brown, did you want to ask a question?
Ms. Brown?
Yes, I do. Can you hear me?
Yes,
Yeah.
I'm sorry. I didn't mean to. I'm sorry, President. Mr. President.
It's okay.
And I too am sorry. I wasn't sure if we were supposed to be waiting or not. And I know that Henry will always help me with that. So my question is, and we're talking about this very, like who is the spoke in the wheel? Because typically as board members, we are asked to contact staff if we have questions about an upcoming agenda item. Could be investments, could be healthcare, could be on any matter. And I don't know who that staff person is also talking to, because there could be a lot of us calling the staff member. And so I don't know that information is not being, shared or talked about, or can they share it among staff, or can they share it back to the board? But it does concern me that that's the practice that we've been having, these conversations before the board meeting, and so the questions don't get asked in public.
Okay, I heard a couple of questions and observations there, so I'll try to take them as I heard them, and if I miss something, by all means, please ask again. On the first observation, which is that each of you are encouraged to speak with staff and when you have questions and you don't know who else staff is talking to. I think that's actually a good sign, because what it says to me is that staff is providing information to you upon request as it's supposed to. And that's not creating a Brown Act violation, because they are not members of the legislative body who would be engaging in some sort of a deliberation outside of a public meeting inappropriately. And the fact that you don't know how other board members feel on a particular topic is also good, because what they have to be careful about is, even if they are approached by a forum of board members asking the same question, what they can't do is say, oh, well, 3 of your fellow board members came to me and asked me the same question. Here's what I said, and here's how they answered. Because if that's what you were hearing, then that would be an open meeting law violation. If it included a quorum of the board or of the committee that had jurisdiction over that topic.
So, Ms. Dunning, let me just stop you right there.
Of course.
I'm not hearing. I'm not sure if other board members aren't hearing. And so I would like some almost, I guess, maybe certification by the staff that they aren't sharing what I'm saying back to other board members or even the chair of the committee, because I don't think that's permitted. And you can tell me if that's true or not. I just want to get that on the table.
So it's important for those who receive your communications, what we say sort of colloquially, to count noses, so that they're not inadvertently or purposefully creating a violation of the open meeting law. It's very common and appropriate for your staff to be communicating with the chair of the board or chair of a president of the board or the chair of a committee about certain agenda items. And to the extent that, for example, you might have raised a topic, Trustee Brown, that nobody else raised, that they believe is important, be addressed in open session or closed session if it's a closed session item. I think it's very reasonable from both a governance and a compliance standpoint for your staff to share that with the chair of the board. But again, or president of the board or chair of a committee, as long as they're not polling the members of the board or of a committee to see how others feel about it, so that they're getting to the point of communicating with a quorum and doing that deliberation outside of the appropriate venue.
Great, thank you.
Certainly. Slide 14, please.
Ms. Taylor?
Just saw another chat. I don't know. Oh, yes.
You know what? Thanks, Ashley. I was going to talk to that. The only comment that I wanted to make is that I heard Trustee Brown say that if we're getting answers from the staff, then we're not asking these questions in open session. And I just want to say sometimes we don't, know, right? And so asking the questions before the meeting to staff seems to me to be productive in terms of making sure the meetings go smoothly, rather than asking questions in open session for whether it's I don't understand this minuscule thing here or whatever. It's this big or ALM. I don't understand ALM. So I think it's appropriate for staff and the board members to have an open communication. I would also, say that I can't imagine staff telling everybody what I say or what anybody says. I don't think I've ever run across that problem, but I understand the concern.
Trustee Taylor, I'm glad you raised that because that was another component of Trustee Brown's observation, which is if you get all your questions asked before the meeting, then doesn't that take something away from the deliberative process? And I would respond to that similarly to what I was hearing from you, which is that if it's a question for clarification, where perhaps it's a newer trustee who's never been through the ALM process, doesn't know what it is, and wants to get a little bit more education on that before being in an open session to talk about it, that seems actually more appropriate to happen before the meeting. But if it is part of the fiduciary decision-making process where it's going into your thinking about why you may vote on a topic, that would be something that you'd want to reiterate in open session. It's not so much of an open, it's somewhat of an open meeting issue. It's also a fiduciary compliance point, which is do make sure that what you care about, what you're considering in connection with particular topics is something that is expressed in the open forum so that you can all hear from one another, deliberate on it, and have it be duly reflected in the record of the meeting that those were the topics that you were discussing.
Yeah, what I was thinking is when I first started, I remember going to our healthcare folks and saying, I really don't understand how this works, and having them sit down with me for that kind of stuff. And I think I did the same with my very first ALM. So, you know, you gotta, I don't want to be asking these questions in open session, or I don't think new people would want to, because then you'll have more questions probably, given the venue you're asking these questions within. So I think it helps facilitate the meeting if your lack of understanding gets answered behind the scenes a little bit.
I think that's true. I think it also, though, may trigger in your staff recognition that maybe for all involved, it's important to have a little bit more setup, more education, more sort of elementary presentation of the topic before they dive too deeply into it. So it can have that value as well. Good comments and questions. Thank you. So in terms of the specifics of an agenda, this comes up from time to time too, when people say, oh, well, I don't know if that agenda gave people sufficient notice of what was going to be discussed. The answer to that is that the open meeting law requires a brief general description, and it actually says it should be less than 20 words of each item of business. Of course, it cannot anticipate your action or the precise iteration of your action, because that's what's going to be decided at the meeting. But it needs to give the public enough information about what is on for discussion and potential action that they can make a reasonably informed decision about whether or not to attend. On your agenda, you also need to know whether items will be discussed in open session or closed session. And if it's going to be in closed session, you need to identify the statute, the statutory basis for the closed session. If you get to the meeting and something that is not agendized that you think should have been agendized, unfortunately, in most circumstances, you can't discuss it too much. You can raise it in your open trustee comment and ask that it be agendized for a future meeting. If somebody says something in public comment that makes you think it needs to be referred to staff, you can do that. Or if it's particularly important and the need for immediate action on a topic came to the attention of CalPERS after the agenda was posted, then in a rare situation, you can ask that board vote, and if 2/3 agree, or if 2/3 aren't there, unanimously agree, then the new matter may be noticed to the public as soon as practicable, at least 48 hours of the meeting. Actually, I misspoke there. This can't happen at a meeting. That's under the Brown Act. Under Bagley-Keene, this has to have happened before you get into the meeting, at least 48 hours before the meeting, to have this 2/3 determination. And Robert, I don't know if you want to weigh in on this one, but because I haven't actually personally dealt with this for a state body. I have for a local public agency. You also can have a circumstance where there's an emergency situation, highly unlikely for a retirement board, although possible in a CalPERS context, where work stoppage or other activity that severely impairs public health or safety or both, or a crippling disaster could create a context where you could add something to the agenda under the emergency provision. But there's some really specific rules too about the notice that needs to be provided for a state body to newspapers, radio, television stations, et cetera, at least an hour prior to the meeting. So a very, very difficult thresholds to meet to add something to the agenda after it's already been duly posted. New issues, of course, can be added to the next agenda. Next slide, please. There are certain topics on which you can have a special meeting under Bagley-Keene that does not require the normal 10-day notice. And I've listed here 7 topics that appear most likely of the 9 that are listed to apply to CalPERS. I won't read them to you, you can read them yourselves, but those are the circumstances where you could have a special meeting on a shorter notice period than the normal 10-day notice. Special meetings are also permissible under Bagley-Keene only when compliance with the 10-day notice provision would, quote, impose a substantial hardship on the state body, or when immediate action is required to promote the public protect the public interest. Again, very high thresholds to meet in order to not comply with the 10-day notice requirement. Next slide, please. This slide talks about additional rules for special meetings in terms of how that notice is to be provided, and also identifies the findings that need to be made in order to meet the requirements for special meetings. So it's not willy-nilly. You need to have findings that set forth specific facts that constitute the hardship to the body or the impending harm to the public interest in order to proceed without that 10-day notice. And then you have to have the 2/3 vote, as I said, and if you don't get that 2/3 vote, then the meeting terminates. But even if you do and you haven't made sufficient findings, you could have a problem when you try to proceed without that 10-day notice. Next slide, please. As I mentioned, when you notice an item for closed session, the agenda needs to identify the specific closed session statutory provision that you are operating under. And each of those provisions are quite specific about what may and may not be discussed under them. And we'll talk about the ones that apply most frequently to retirement boards. Next slide, please. The ones that I've observed most frequently invoked by public retirement boards are personnel matters. So the appointment, employment, evaluation, or dismissal of personnel. That is not typically able to be used for, say, a consultant. It's only for personnel. You have a special provision for CalPERS and CalSTRS, actually, that relate to the recruitment, appointment, employment, or removal of your CEO or CIO. That's section 11126 subdivision G. A separate closed session provision relates to pending litigation. Pending litigation, one would think in the vernacular means something that has already been filed, but it doesn't, it's not limited to that. It covers both litigation that has already been filed as well as significant exposure to litigation. Real property negotiations, but there you need to list typically you need to list the property address, and the topics to be discussed in closed session are limited to the purchase or sale prices, an exchange or a lease, and to give instructions to the negotiator regarding the price and terms of sale. And you have to list the negotiator who will be attending that closed session with you. This last bullet point is much broader than the rule that applies to local public agencies. And it says that a state body that invests retirement funds, so retirement, the CalPERS board, all investment decisions, including real property investment decisions, may be discussed in closed session. That's a much broader exemption than applies to the locals. Some limitations apply, however, when you're discussing shareholder votes on corporate stock. I'm assuming, since I see no questions in the chat, that I'll just forge ahead here. But by all means, please do stop me if you have questions on any of these topics. Next slide, please. Questions? No. So I've completed here. Any questions on Bagley-Keene before we proceed with our conflict of interest discussion?
Yes, Ashley, I have a question on the real estate closed session item. You mentioned that the address of the property. So if you are listing the address of the property, to me that to some degree compromise what you're discussing and could impact your strategy from outsiders.
So that's an interesting one, and I'm glad you raised it, President Jones, because I know there's a nuance here for CalPERS where real estate investments, I believe, fall within the same rubric as normal investment decisions that can be discussed in closed session without that particular information. The normal rule for real estate purchase and sale of a property is that you do have to list the address. And I don't know, Robert, if you want to weigh in there. I keep looking at you to see if you want to say something on this. If, say, for example, there's a carve out.
Yeah, in the investment section that covers just for CalPERS and other retirement systems that are subject to Bagley-Keene, they don't have to comply with the requirement to identify the address.
Okay.
Right, and presumably that's because that exception, the investment exception, swallows the normal rule. So if a purchase and sale of a property weren't part of your investment decision-making process, well, then maybe you'd have to follow the normal rule, but presumably it's all part of your investment decision-making. So perhaps that's where we get to where Robert Carlin said you land on that.
Okay.
It makes sense to me.
Okay, done. Okay, I see no additional questions from, wait just a minute, Mr. Miller.
Hi, I have a question back on slide number 8. It talks about both subsidiary bodies and committees and advisory bodies, and has the 2 or more persons or 3 persons. But we generally, everything I hear is about, not having 3 or more persons from the board. Is that based on the quorum size of our smallest subcommittees, or is that based on this? So for example, if all our committees had, were a committee of the whole, would we still have the 3-person kind of, operating rule for, what constitutes a problem for us? Or is it based on the size of our subcommittees? So for example, when 3 of us can't go to a training somewhere, because that's too many.
Right. There were a couple of questions and observations in there, so I'll try to unpack it a little bit. If the one that sticks out to me, if you said if all of your committees were committees of the whole, would that change this? And I think the answer is probably yes, in the sense that if all of your committees were committees of a whole, then a quorum of all of your committees would be just that, a majority of the whole. But that's not the case. This rule that's in bullet point 2 does not derive, though, from the size of CalPERS board's committees. It's the bodies if composed of 2 or more persons and exercises authority of the state body. That's what delineates it or separates it from the 3 or more persons rule before or after it in the advisory body section.
Yeah, so those would have to be established either by some sort of rule or by a decision by the board versus 3 or more of us attending the same training at Wharton, for example.
Right. Those exactly.
Okay, thank you. That makes it a little more clear for me.
Good.
I have another question, Ashley. Can the board members, with social media now, communicate on social issues, none not related to CalPERS? Business.
So I know there was recent legislation passed, although I'm getting outside of I haven't focused on this yet. There was recent legislation passed dealing with social media communications by trustees. I was looking at it in a Brown Act context, so I actually haven't looked at it from a Bagley-Keene context. That provides you a little bit more protection, I think, in your social media communications, at least for the window when this legislation is going to be in effect. But what I'd say more generally, just setting aside that legislation for a moment, is when you're not talking about something within the jurisdiction of CalPERS, it shouldn't be covered in terms of the rules that apply to open meetings by CalPERS board members. If any of you have, or because others of you have other public roles, there might be other rules that apply to you, but the open meeting laws that apply to CalPERS should only govern your communications that relate to matters as to which CalPERS has jurisdiction. Does that make sense?
Yes, it does. Okay, thank you. Okay, are there any other questions on this subject matter from the board? Because I'm going to see if there are any members of the public who would like to make comments on this before we move to the conflict of interest. So seeing no additional questions from board member, Mr. Fox, are there any members of the public who wish to make comments on this section?
Mr. President, there are no callers on this subject.
Okay, thank you. Okay, Ms. Gunnan.
Thank you, President Jones. If we might go to the next slide, I'll just introduce my colleague and our next topic, which is the conflict of interest rules applicable to board members and staff at CalPERS. Slide 21, please. The primary duty rule derives from the duty of loyalty that is one of your fiduciary obligations. And the obligation to avoid conflicts derives from the fact that in addition to being a trustee, you're all public officials who have rules that prohibit you from engaging in conflicted transactions. So very big picture, you have a duty not to acquire material benefit from a third party with respect to your activities for CalPERS. And there are both statutory and common law conflict of interest prohibitions that we will talk about. I just saw a note come up. Somebody had a question.
Okay, Ms. Taylor, are you asking a question based on what we just completed, Ms. Taylor, or are you?
Yeah, I'm sorry. I didn't think of it till just as I was, she was changing.
Okay, go ahead.
So
Go ahead.
you mentioned social media, Mr. Jones, and we're discussing whatever we're doing, we're discussing something other than CalPERS, but we can't post to social media CalPERS stuff, right? Is that a violation? Or is there a specific, if I'm directly talking to somebody and tag them that's on the board, then that's a no-no? What I don't understand.
I'm not sure if you were directing that to me or President Jones, Trustee Taylor, but so if you simply tag somebody who's on the board on something that's completely unrelated to CalPERS, I don't see what line you would be crossing. Where I thought you were going was with social media that is a CalPERS forum. And that clearly is, even if you're commenting on something other than what you think is CalPERS business, if it's a CalPERS medium, like a CalPERS online presence, then that could create issues.
I think where I was going is, so say on my Twitter account or my Facebook account, I decide to, after a decision was made or before a decision was made, say, this is the way I'm going to vote.
Oh, that's a problem. Yes.
Okay.
Yeah.
Okay. Or this is, I'm glad I voted against this type of thing. If it already happened in open session, I imagine that's not a problem.
Yeah, I mean, you're sort of on a fine line there because you're a board of continuing jurisdiction. So the fact that you made one decision one day doesn't mean that it won't come back to the board. So I wouldn't take too much solace in a decision already having been made as the place where you can suddenly, be out there.
Ultimately, that's a no-no.
Yeah, but
I wouldn't recommend it, but that doesn't necessarily mean it's violating the law.
Okay, thank you.
You're welcome. Okay, all right. So now next slide, please. Oops. Oh, I saw another question. I don't know, President Jones, if this is a question on the last set or the set.
Mr. Miller, is your question on the
This was a follow-up to Teresa's question. It brought to mind, and I think I know the answer, but I'll ask anyway. So, for example, when in, say, my Facebook feed, when a CalPERS announcement about, oh, this is the time to make sure you're aware that it's open enrollment time, don't miss your opportunity, and I click like on it, is that something I probably shouldn't do then? Or is it just the safest bet just to not interact with anything from CalPERS or anything about CalPERS on Facebook? Because, for example, stuff like that, or there's events that get announced, or for example, Treasurer Ma has a lot of different events around the state, and if I see something that's really interesting, I might like or share it, and it may be peripherally and related to something we do, or at least our constituents. So.
I think that may need a little deeper dive, Trustee Miller, before I answer formally on it. It seems to me there's got to be a distinction between liking an announcement about something that's valuable for your members to know about versus making a statement of your views on a particular topic that's within the jurisdiction that you're actually going to act on. Those seem to me to be quite different from one another. But we can certainly circle back on
Thank you.
that.
Appreciate it.
Yeah, well, Ms. Dunn, then I would suggest that this whole social media area, if you could take a deeper dive and provide the board with some parameters and guard posts, if you will.
Absolutely.
Okay. Thank
Yeah,
you.
and I'll look at that new legislation as well. It came to my attention last week, and that may also be helpful for you to know about, and for me to include in this discussion.
Okay.
In my follow-up.
Okay, thanks.
Great, thank you. All right, so moving on to the conflict of interest principles. Big picture, the board members are not to participate in matters that impact your finances in a manner that's different from how it impacts retirement system membership generally. And we'll talk a lot more about that, both under the Political Reform Act and Government Code Section 1090. But that's sort of a big picture principle that you should keep in mind. And this next topic, we will also get into in some detail when Amber talks about the Political Reform Act rules. But the big picture, board members shall not participate in a matter if it's expected to impact your own employment or your personal finances. And note that while it's not it doesn't absolutely protect you from violating the conflict of interest rules, the $2,000 threshold that you have on your Form 700 for reporting your ownership of stocks and bonds is one parameter by which financial interests are measured. And then you have other Form 700 disclosure thresholds for other types of financial interests, and Amber's going to get into that as well. Next slide, please. Final big picture point is that in the conflict of interest world, the laws are very different depending on whether you're talking about your general decision making on topics versus the entering into some sort of a contract. And because the rules relating to conflicts of interest in contracts are quite different from the general rules. And Amber's going to talk about the general rules under the Political Reform Act next. And then I will circle back and talk about the rules under Government Code Section 1090, which is the law that applies specifically to conflicts of interest in terms of contracts. All right, Amber. Next slide, please.
Thank you, Ashley. So now we'll be talking about conflicts of interest under the Political Reform Act. And big picture, the Political Reform Act is the body of law that governs government ethics and campaign finance in California. And it is both interpreted and enforced by the Fair Political Practices Commission. So you might hear me say FPPC for short throughout the duration of this presentation. And just an important point, Ashley will be talking about 1090 after I talk about the Political Reform Act, conflicts of interest, but another distinction is that the FPPC can provide advice on your obligations under the Political Reform Act and Government Code 1090. However, it only has enforcement authority over the Political Reform Act conflicts of interest. It does not have enforcement authority over the 1090 conflicts of interest. So here again, we'll just be talking about the Political Reform Act conflicts. So the basic rule is that no public official shall make or participate in making or use his or her official position to influence the making of a governmental decision in which the public official or a member of his or her immediate family has a financial interest. And immediate family, for purposes here, is limited to a spouse and dependent children. And the rationale being that you're looking to curb both the appearance and actual impropriety by the public official, essentially making it impossible for a public official to allow their personal temptations to detract them from their duties to the agency and to the public. Next slide, please. So when you're confronted with this question of whether or not you as a public official have a disqualifying financial interest in a governmental decision, the FPPC has created a multi-factor test that creates a roadmap for doing the analysis. Next slide, please. And this is a test that has been actually kind of fine-tuned over the decades by the FPPC. The first question involved is whether or not if we're talking about somebody else, whether or not there's a public official involved, and all board members and CalPERS staff are public officials. And I will just note that the term public official is actually quite broad for who is covered under these laws. It includes not just elected and appointed officials, but also public employees. Oh, and also in some circumstances, independent contractors, depending on whether or not they either are essentially acting in a staff capacity or if they're able to exert significant influence over decisions by the government agency, might be captured as a public official as well. The next prong is whether or not the public official is involved in a decision. So these are the governmental decisions like for trustees voting on a matter, helping to influence those conversations that lead to a vote, appointing a position, hiring, entering into contracts. So any of those types of decisions. And it's not just the actual voting or final decision making, but the influencing that happens beforehand. So essentially, if you're involved in a way that isn't ministerial in nature in that type of decision, then you're likely involved in a governmental decision. The next three prongs are where you really get into the heart of the analysis that goes into play. The first one is looking at whether or not there's a financial interest in question. And what is a financial interest? The Political Reform Act identifies a few of them. Financial interests include business entities, so ownership or management positions in a business entity, real property, income, sources of income, gifts. So a person or entity from whom you've received a gift is a financial interest. And then finally, your own personal finances. We note here that if you file a Form 700, which I think most people attending today do file Form 700, that Form 700 is meant to be your own and the public's roadmap to help you identify when you might have a conflict of interest. That's where you're disclosing your sources of income, community property share of your spouse's income, sources of any gifts that you've received, rental property, income, things of that nature. Even if it's not on your Form 700, the financial interest might still be the cause of a disqualifying conflict of interest. And the best example here would be your own personal residence. So you're not required to disclose your personal residence on your Form 700, but there are circumstances in which you might have a disqualifying interest in your own home. The next prong is once you've identified that you're making a decision and there's a financial interest involved, the question is whether or not it is reasonably foreseeable that the decision will have a financial effect on that financial interest. And so there's sort of two pathways that you go when you get to this prong. If the financial interest is the subject of the decision, then the answer is yes, it's deemed reasonably foreseeable that your decision will have an impact. So, this would be an applicant before a board, or, for example, a business that the board is considering investing in. The other prong, and I see a question, the other prong is if the financial interest is not explicitly involved in the decision, then the analysis is whether or not it is a realistic possibility that the decision will have a financial effect on your financial interests and not merely hypothetical. And I do see a question if we want to.
Yes, that's me. What is an example of disqualifying interest in your home?
Oh, so that would be, and this actually often comes up on city councils or county supervisor boards when you're voting. It could be, for example, if you're voting to change the location of a stop sign and it's within 500 feet of your home, and it could change your property value, for example.
Okay. Okay, thanks.
Yeah, you're very welcome. So then the final prong is even if you've identified that there will be an effect on your financial interest, the final inquiry is whether or not that effect will be material. And within the FPPC regulations, there's what's called a materiality standard for each one of those interests that I just outlined. So you would look to if it's a business entity or if it's real property, and so on. You would look at those materiality standards to determine whether or not it is material, in which case you would then be looking to see whether or not any exceptions apply, or if you have to take the steps to disqualify yourself from voting on the matter. And I think I see another question. I think.
No, that's still me, the last question.
Okay, great. Next slide, please. So one of the functions that the FPPC serves for the public is that it provides advice to individuals and entities who are regulated by the Political Reform Act. And in this instance, we wanted to highlight one of the advice letters that was issued here to a member of a public retirement board. And the question was around whether or not that retirement board trustees stock ownership in a company that the retirement system was considering investing in would be a disqualifying financial interest. And the answer was yes, so long as the ownership interest was 2,000 or more. That goes back to the point that Ashley made when she was introducing the idea of conflicts of interest. But one notable thing is the FPPC also noted the trustee could dispose of their financial interest. By doing that, they would be able to vote and not have to disqualify themselves if they were voting on a matter that otherwise would have impacted the company in which they owned stock. There's also a mechanism by which a public official can set up a blind trust in which they abdicate all control and really all knowledge around what happens to the assets within the trust. And if they follow the protocols set forth in FPPC regulations to do so, then in that circumstance, they would also be able to vote and not have to disqualify themselves. Next slide, please. If you do identify that you have a disqualifying conflict of interest, then you are required to recuse yourself from the matter, and there is an outline for how to do so. A specific way that has to be done. At the meeting at which the vote is to be held, if it were to happen at a meeting, it would be necessary to first state the fact of the financial interest. You also have to state what the financial interest is. That's disqualifying. And then in the case of a trustee, you would actually leave the dais, or in the world of Zoom, I think turn your camera off maybe and leave the room, and let maybe staff text you to know when to come back in. And this final bullet point is raising this is a very important distinction, and Ashley is going into it next. But when it comes to a Political Reform Act conflict of interest, the board, the agency, is not precluded from making that decision as a whole. Only the individual board member is precluded from participating in that decision. With a 1090 conflict of interest, the entire agency is actually precluded from entering, in that case, into, it would be a contract. Next slide, please.
We have a question, Ms. Yee.
Yes.
Thank you, President Jones. My question had to do with whether that financial interest that is present for the principal also extends to designees.
I'm not sure I understand your question.
So in other words, if I had a financial interest, I would disqualify myself from the decision-making process, but that would also mean my designees would be disqualified as well. Yes.
Oh, I see. No, so oh, that's a really good question. No, so essentially an alternate.
Yes.
Okay. No, I think the financial interest is individual to the trustee, and so it would be individual to the alternate. But if it's okay with you, can I follow up and just confirm that for?
Sure, yes. And I only ask because with respect to some of the other boards where there are, excuse me, for example, campaign contribution conflicts, it only applies to the principal and not to designees. So
I guess one of the questions there would be whether the principal has a relationship with the delegee such that the influence perhaps already had occurred in terms of what the vote might be. And so I think that is a really interesting question, Trustee. We can get back to you on it to see if we can find any specific guidance. But on the one hand, it's an individualized assessment. Does the person have a personal financial interest? On the other hand, there's this special relationship between the principal and the delegee on the board,
right,
that may influence the answer too.
Yeah,
Okay.
yeah, Ms. Dunn, we also have other members that have delegates, so make sure that comes to the whole board.
Certainly.
Thank you.
So in the event that there is a violation of a Political Reform Act conflict of interest, there are a number of consequences that range from just an administrative penalty to a potential criminal conviction. There are two sort of pathways for enforcement. One, the FPPC can bring an administrative action, which brings with it monetary penalties of up to $5,000 per count. Separately, the Attorney General or a district attorney, depends on the jurisdiction, but the Attorney General in this case would be able to bring a civil action And under a civil action, the penalties could be up to 3 times the amount of the benefit in the event that the public official did in fact benefit after voting on a matter in which they had a disqualifying conflict of interest. And in rare circumstances, the decision may be voided. There's also within the Political Reform Act provisions that allow for staff, for example, to be dismissed from an agency as a consequence of violating the conflict of interest rules, subject to relevant personnel rules. Next slide, please. And are there any more questions?
Okay, I don't see any additional questions from board members. So does that complete your presentation here? I will check with Mr. Fox to see if we have anyone from the public who wish to make comments.
That
So,
completes our Political Reform Act presentation, President Jones, but not the presentation.
Okay, so
So we need to go back. Right.
let's just see if there are any questions at this stage. Mr. Fox.
Yes, Mr. President, there is one caller, Mr. Tim Behrens of CFR.
Okay. You have 3 minutes, Mr. Barron.
Thank you, President Jones, members of the board. My question is for the last presenter. Is it a conflict of interest under the Political Reform Act for board members and or CalPERS staff to publicly make statements at a CalPERS open meeting regarding an election for a board seat?
The Political Reform Act conflict of interest rules are limited to economic financial interest. It doesn't sound like they would cover the scenario that you're describing.
Thank you.
Okay, thank you. Okay, proceed, Ms. Dunn.
Thank you, President Jones. All right, next slide, please. So just to remind people where we're going in this presentation now, I will be describing and explaining Government Code Section 1090, and then I'll turn it back to Amber for a discussion of campaign contributions and post-employment activity prohibitions. Okay, so some of this will look familiar and some will not. The general rule that public officers and employees, so same group of people, shall not be financially interested in any contract made by them or any body or board of which they're members applies. The difference here is that one difference is that board members are presumed to be involved in all contracts under your board's jurisdiction. So as noted here, and as Amber mentioned earlier, even disqualification and recusal of the interested member will not permit the board to go forward with a contract unless you fall within one of the exceptions, types of exceptions that we'll talk about. There are 2 different types of exceptions. There's a remote interest exception and a non-interest exception. If you fall within those, the board can go, the board can go forward with the contract. If not, you just can't enter into the contract. Interested employees may not participate, so they don't have to give up their job, unlike a board member who might have to resign from the board in order to have the board be able to proceed. And even then, it doesn't always cure the problem. Interested employees may recuse themselves effectively. Several years ago, about 5 years ago, the reach of the statute was broadened to prohibit individuals from aiding and abetting in the violation of a Section 1090 by a public official or employee. This came out of the prosecution of some trustees from another public retirement board that led to the California Supreme Court decision of Lexon that I'll talk about on the next slides. And following that, the legislature, I guess, upset by this situation, broadened the scope of 1090. And next slide, please. Similar to the Political Reform Act analysis, there's a multi-factor or multi-step analysis to determine whether there's a Section 1090 conflict. And it starts with the same question that applied to the Political Reform Act, and that is the person involved a public officer or employee? So same answer here, all members of the board and your staff would fall within this first category as a yes. Second question, is there a contract? Note that the types of contracts that have led to courts determining that there was a 1090 violation have been broad and have sometimes been multi-part. So some of you may recall the state superintendent of education, Honig, was charged with a 1090 violation and ultimately imprisoned, and the contract involved multiple different parties and benefited his spouse. So you have to look at that, what the courts have called a long and windy trail, to determine whether or not there's actually a contract. The third question, was the person involved in making of a contract? Again, broadly defined, similar to the Political Reform Act, in that it goes back to well before the entering into the contract, but also looks to whether you were involved in, say, developing the terms for maybe putting out the RFP. Were you involved in negotiating, certainly modifying it, soliciting bids? So any part of that process, including up until the entering of the contract, would be considered involvement. Unlike the Political Reform Act, you have a financial interest test here that is either positive or negative. You could be adversely impacted by a contract and be deemed to have a financial interest in it under 1090. Similar to the Political Reform Act, your interest may be direct or indirect. And then, as I mentioned, there are two different types of exceptions that could be invoked to determine that there either is not a 1090 violation, or, and that's the case when you have a non-interest, or that the disclosure and recusal will be sufficient, and that's a remote interest. Worst case scenario, very unusual, highly unusual for a public retirement board because you have multiple members, and so the rule of necessity normally would not be able to be invoked for a multi-member board, but it has been invoked in other well-known circumstances where a person is deemed to be the only one who can engage in that, enter into that contract or engage in the negotiation of that contract. This came up both for Senator Feinstein when she was mayor of San Francisco and for Governor Brown when he was mayor of Oakland, because both of them had strong mayor provisions in the city charters that resulted in them being the only ones who could enter into certain contracts in which they otherwise would have had disqualifying financial interests. And as to both of them, the courts ultimately held that the rule of necessity applied. As I mentioned, it is a violation to aid or abet another person, another public official or employee's violation as well. So you are your brother's keeper in this arena. Oh, I see it. I see a question.
No.
Oh, was that from before?
Yeah.
Oh.
I'll monitor it.
Oh, I see. Okay. Sorry. I just want to make sure to not speed ahead here. All right. Next slide, please. All right. So on this slide, I've talked about some of the non-interest exceptions that are most likely to be applicable to CalPERS. One is the governmental salary exception. This is an exception that applies very differently under Government Code Section 1090 than the Political Reform Act. And it's, sort of beware of this one, because under the Political Reform Act, governmental salary is not considered to be a financial interest. So that's why if you're a public employee, you don't report your public employee salary or your retirement benefits on your Form 700, because your compensation as a public employee is not considered a financial interest. That is not the rule under 1090. So your governmental salary is a financial interest. And therefore, it seems somewhat like a non sequitur. If you have a governmental salary exception, how could it be that your governmental salary counts? Well, it does. And what the governmental salary exception applies to is a circumstance where there's no change in compensation to you. The contract is not with, and it does not directly affect your own employing department. But it is a contract with your employer. And that's the circumstance that was discussed in Lexon versus Superior Court that we'll talk to in the next slide. I'll talk about in the next couple of slides. The next non-interest exception that is very important for public retirement boards is called the Public Services Generally Provided provision. And that's in subdivision A3 of section 1091.5. And we'll talk about that on the next slide as well. The third one that's particularly important is just to note that in order to be reimbursed for your out-of-pocket expenses, your actual and necessary expenses performing your public duties, because that involves sort of contract-related rights, you need to have this exception that allow you to get reimbursed by the agency. Fortunately, you do. So I can do next slide, or President.
Okay, we have a question, Ms. Dunning. Mr. Perez.
Thank you. Can you provide an example of the government salary exception? I'm not tracking.
Sure. And maybe if we go to the next slide, that will help too, because that's where I think I talk about it first. Okay, yes, so this is it. Good segue. And I'll give you a little bit of background because that's the hypothetical that's not a hypothetical that I'll use that was discussed in the Lexon case. The contract, there were two different contracts that were at issue or that were discussed in that case. The circumstance involved the City of San Diego retirement system and the City of San Diego itself. And they had entered into an agreement to phase in increases in contributions that the city owed to the retirement system, and not to apply a different agreement that they had before about a balloon payment that would have been due if the funding level of the system fell below 80%. So that was one contract. The other contract that was implicated were the normal MOUs that were entered into between the city and its labor unions. And those MOUs provided members with a higher benefit formula. So this was back in the early 2000s, the 3 at 50 formula, 2 at 55, et cetera, were negotiated and provided to the employees. The allegation in the complaint or in the district attorney's charge was that the active employee members of the retirement board had agreed to give the city a break on its contribution obligations to the retirement system in exchange for having their benefit formulas enhanced. That was the allegation. And what the Supreme Court held was that the government salary exception did not apply there because the benefit formulas of the employees were increased as a result of those MOUs. Had there been no MOUs that were implicated in that litigation, and it were simply the contribution relief agreement that was entered into between the city and the retirement system, then that presumably could have been subject to the governmental salary exception, because at that point, you would have had a circumstance that meets the second bullet point. No board or staff members' government compensation was impacted by that contribution relief agreement. And two, the agreement was not with any of the board members' employing department. It was with the city as a whole. A circumstance that's different from that, where you would have a contract that is with the person's employing department, would be, say, if the retirement system were to enter into a contract to get additional in that law enforcement presence at board meetings, and a member of the retirement board worked for the department that was providing that additional law enforcement presence, that would be a circumstance where the member on the retirement board who worked in the department that was on the other side of that contract would need to disclose and recuse themselves, because while their compensation would not be impacted, it would impact the department for which they work. Does that answer your question, Trustee Perez? Yeah, okay. Great. Next slide, please. This slide describes the scenario I just mentioned, which is the contract that is with or directly affects the board member's employing department, where your compensation is, the board member's compensation is not impacted. So in that case, the retirement system can go forward and enter into that contract with the sheriff's department, say, or with the county that implicates the sheriff's department services, so long as the deputy sheriff who's sitting on the board of retirement has disclosed that they work at the sheriff's department and therefore are going to recuse themselves from decision-making with respect to that topic, because it's considered a remote interest under a different provision of the 1090 exceptions, which is 1091B13, rather than a non-interest. Next slide, please.
Question, Ashley?
Certainly.
Yeah, that seems to really reach a very broad scenario, because we have members of cities, we have members on the board of school districts, so we're making decisions about their employers. How is that, how is that handled?
No, that's an excellent segue to this next slide. And
okay.
that was the conundrum in Luxon, because the argument that was being made was that the governmental salary exception applied and allowed the votes to occur, and the Supreme Court did not agree with that. Thankfully, and I had the great honor of representing CalPERS as amicus, as amici in this, and we argued on behalf of CalPERS in this litigation that a different exception should apply. And that is the public services generally provided exception. This is a statute that had not been interpreted by any court before relative to public retirement benefits. And actually, it hadn't been interpreted by very many courts at all. It had been applied by some attorney general opinions in the context of water districts, and water districts where the board would include some district owners who were water district owners, I guess, who were required to be on the board. And the analogy there was that you as a retirement board are anticipated and in fact required by statute to have members who are members of the retirement system. So your membership necessarily includes people who will be recipients of retirement benefits under formula, for example, in this, like in the San Diego situation, the recipients of the benefit formula that are negotiated in MOUs will be paying contribution rates that are based on the assumptions used in your valuations, will be impacted in various other ways that are the same as similarly situated individuals within your membership. And the court agreed. And the court concluded that this exception, this non-interest exception, may be invoked as to contracts that provide a benefit to the public official that is one of those benefits that the public agency generally provides, where there is no opportunity for the exercise of individualized discretion that would allow for preferential treatment to be provided to the public official. You're not setting up a loan program that has, subjective factors that are considered that a public official will then apply to benefit from. And that the public official and the agency's constituent, so in this case, we have your members and beneficiaries, have access to benefits on the same terms and conditions without respect to the public official's status. The example that we provide here is your PEMCA benefits. So you will determine what the premiums are, what the rate structure is, et cetera. All of that impacts some of your members on your board. But as long as they are getting those benefits on the same terms as similarly situated members, and you're not talking about some discrete group of people that have been tailored to include the public official on your board and a few others, it should fall within this exception. I say that because one of the points in the San Diego litigation, Lexan, involved a benefit that was provided only to union presidents. And one of the trustees who had been indicted on the board was one of those 3 union presidents. And the court concluded that this exception did not apply to him because that was too small a group. It was too individualized a benefit determination to fall within this public services generally provided exception. So when you talk about contracts with cities and contracts with school districts, President Jones, or contracts with whomever, with your various contracting agencies, to the extent that those contracts are provided in a way that is not impacting your board member in any way differently from anybody else, this is the exception that should apply, not governmental salary. And you only need one. Fortunately, you only need one exception. Okay, next slide, please. There's also a remote interest exception to 1090 that relates to the settlement of litigation. So you may have a lawsuit that is brought against the retirement system on behalf of a class of members, and one of your board members or one of your employees may actually be within that class simply by virtue of their membership. And there are various things that you need to do in terms of making sure that board member has disclosed that interest and recuse themselves from participating in the litigation on behalf of CalPERS. But if you do that, and if CalPERS is represented by legal counsel in litigation and the court makes a particular finding, then you can go ahead and settle that case. But otherwise, you would not be able to settle that case because you would have somebody on both sides of the transaction, and a settlement agreement is a contract. Next slide, please. Ordinarily, as I mentioned at the outset, and Amber also mentioned this, a board member cannot escape liability for a contract law violation by recusing themselves unless it's a remote interest. And therefore, the answer to a very unhappy public official when they receive this advice is that they need to resign from the board in order to avoid the conflict. And even that hasn't always cured the problem. The scenario that we see with more regularity than others is when you have a board member who would prefer to be, say, the CEO of the organization, and try to resign from the board in order to be eligible for that position. That's not going to work if they've had any participation at all in terms of determining what the parameters are for the appointment of the CEO. And so that's resignation unless an exception applies. Staff members with a financial interest must be screened, or they can irrevocably renounce their interest. I've had that as well, where people view that their role as so important with respect to their agency in terms of assisting with the decision-making process that they will irrevocably renounce their interest in the matter, in which case they should be able to proceed. Violation of this law is a felony. It's not a misdemeanor. It can result in imprisonment, permanent disqualification from public office, and fines. There's also a requirement of disgorgement of all benefits received under the illegal contract. And there, what you see sometimes in some of these cases where, say, the city will purchase a piece of property, there's a 1090 conflict that exists with respect to the person who sold the property to the city, because maybe they also sat on the board or a relative did or something. In any event, the city gets to keep the property, but the person who got the money for the property has to return it to the city. So it's a pretty bad deal for the person who is convicted of the crime. Next slide, please. That's it. Any questions before we move on to the next shorter portion of our presentation, and then we'll finish up.
Okay, I see no questions from the board. Mr. Fox, do we have anyone from the public who wish to make a comment on this section?
Mr. President, we have no callers on this subject.
Thank you. Okay, proceed, Ms. Dunning.
All right, next slide, please.
Okay. So for this next section and our final section, I will be talking about a few other places where conflict of interest rules come into play. Think of this as sort of the miscellaneous section of conflicts of interest. We'll be looking at when campaign contributions can present conflicts of interest, what the common law rules are around conflicts of interest, and a few ways that the conflict of interest rules look at post-employment and post-public service activity. So the first one is when a campaign contribution can potentially present a conflict of interest. And I think, one sort of big picture point is that overall in California, campaign contributions to a candidate's campaign for elective office, for the most part, don't create a conflict of interest. This is the one exception, and it's found in Government Code Section 84308. And what this law, it applies to retirement board members receiving campaign contributions for election to a different office. So this only applies if you are on an elected body elsewhere. But in connection with proceedings before the retirement board on licenses, permits, and other entitlements for use, including investment contracts. So the whole idea behind this is that as a trustee, if you have a campaign donor to your campaign committee, if they then have a matter before you as a trustee of CalPERS, then that campaign contribution could present a conflict of interest. And again, like the other conflict of interest under the Political Reform Act that we looked at, there is a mechanism for disqualification. One point on the extent to which this rule applies, relevant here for CalPERS. There's an FPPC advice letter which does confirm that 84308 does not apply to constitutional officers who are serving generally, but in particular here, who are serving on the CalPERS board. Next slide, please. So there are a few different relevant limits and also timeframes here. One, board members may not receive or solicit campaign contributions of more than $250 from financially interested persons while the proceedings are pending, and then for 3 months thereafter. But in the circumstance that a proceeding comes before you and you find out that a campaign contributor is the party before your board, you actually have to go back 12 months. So contributions that are made or received in the 12 months before a proceeding would be disqualifying. So there are 2 ways that it can be handled if a board member determines that they've received a contribution from a donor who now has a matter before the board. One, the board member does have to make a disclosure on the public record about the contribution and who it was received from, and disqualify themselves from voting on the matter. And the alternative, the board member may return the contribution within 30 days from the time that they should have known about the contribution and the proceeding. And if the contribution is returned, then the board member does not have to disqualify themselves. Next slide, please. So this is a conflict of interest rule that's found in the public retirement and pension plan rules. And here the idea is that retirement board members may not sell investment products to both retirement board members and staff may not sell investment products to any California public retirement system. So this is a cross-selling ban, and again goes to the overarching principle that we've been talking about, which is that board members and employees shall not have personal interest or personal gain in the making of investments. And I see I think
a question, Ms. Middleton.
Yes, thank you. Mr. President, I'd like to go back to that last slide regarding campaign contributions. And as I understand it here, you've got a 2-part test, one being that you are aware of the donation that has come in to you, and then secondly, that you learn that someone who has made a contribution has a matter pending before CalPERS. So to take an example, someone in 2020 makes a campaign contribution to you when you were running for another office. And then you learn at some point in time in 2021 that they have a matter before CalPERS. Do you at that point return the donation or simply recuse yourself from the matter before CalPERS?
So the requirement is to return the contribution within 30 days from the time that you either know or should have known about the contribution. and the proceeding. So I think there would be, just for practical purposes, you would, sorry, there's a comment, want to do, your own due diligence in determining, returning the contribution. And I'm sorry if I'm not answering your question.
Well, what I'm getting at is in running for office, you receive campaign contributions from many individuals. Those are all reported in California out on your Form 460. And then after, at a subsequent date, someone who has previously donated to your campaign, you learn has a matter now pending before CalPERS. You couldn't have known that they were, if you did not know that they were going to, at some point in the future, have a matter before CalPERS, you wouldn't be returning the donation within 30 days because you had no idea that there would be an issue coming up.
Right. No, you're right. And so in that case, when you learned of the proceeding, then you would have 30 days from that point to return the contribution and able to participate in the matter.
Okay.
And if you want to keep the contribution, you can keep the contribution, but then you would have to you would be disqualified from participating.
Sure. All right.
That it, Lisa? Miss Melton?
That's good, Henry.
Okay, Ms. Yee?
Thank you, President Jones. Along the same line as Ms. Milton's question, I think the practice has been in terms of understanding whether there is a proceeding pending. Is it driven also by the timing of when it would come formally before the body for decision? I mean, a proceeding may be pending, but the decision may not be forthcoming. And I guess I just recall in other board settings, we always do a conflict check based on what's been agendized or for the meeting notice of cases coming up. So that's typically, I think, how a conflict check is done. And then my second question has to do with the $250 amount. In order to participate, that contribution would have to be returned within 30 days from the time that should have known about the contribution, the proceeding before the board. Is it the full 250 or is it just to get down below 250? Because I've seen.
I'll answer your second question.
Okay.
The disqualifying amount is more than 250. So a donor can give $250 exactly, and the trustee would not be disqualified.
Disqualified. Okay.
Right.
All right.
And then your second question, I just want to make sure that I understand it, and I might ask Ashley to weigh in as well, but is your question getting to when would a proceeding be considered pending?
Correct.
Okay. Okay. I mean, I would think for the from the trustee perspective, it would be when something is agendized for your consideration. But I would like Ashley's perspective if you have a different viewpoint or additional viewpoint on that.
I think that has to be right. I haven't reviewed it specifically, but there has to be a bright line that you can determine what is the date, and the noticing of the agenda item seems to me to be very reasonable as determining what that date is. And I don't know if staff wants to respond in terms of how you do your conflict assessment for CalPERS, because Trustee Yee mentioned other boards. I'm not sure what CalPERS does. There was another component I heard of Trustee Yee's question that relates to donations that are over 250. In Amber, I think it's the same as gifts, isn't it? That you can say somebody receives a campaign contribution of $500. Can they return 250 to be below the 250 and under threshold?
Yeah, absolutely.
Thought so, yeah.
They can reimburse down to, so that the total contribution is 250 or less.
Right.
I mean, I'm looking at the, oh, I'm sorry. No, I was just going to say, I'm looking at the the two bullets under general rules. Yeah, I mean, the question is, when is the proceeding pending? Because if it's not agendized for board action, there's a possibility that that 12 months would toll. I was looking at those two things together, and they generally do kind of go together, but just want to get an opinion about that.
Well, it refers to the proceeding and the board participating in the proceeding. So it would be logical that the proceeding that's referenced is the one within which the board may participate, and the board isn't participating in the administrative process leading up to it, say in a disability retirement, for example. But they may well be involved in the proceeding once, or they would be once it's agendized.
Right.
So I would interpret proceeding in the same manner in that final bullet point. Proceeding, you participate in the proceeding that has been agendized and not something prior to that.
Okay. Thank you.
Okay, Ms. Middleton.
Sorry, but this is an important area, and I want to make sure I get everything correct. This applies to matters where there's going to be a proceeding before the board. Does it apply to a campaign contributor who may have a contract or provide a service to CalPERS, but that contract or that service is something that is dealt with at the staff level and does not come to the board for approval?
I would say no, because 84308 applies to agencies and officers, and the officers are the elected or appointed officers of the agency and not the staff members. So if this is something happening purely at the staff level, then 84308 would not apply.
Okay.
I think Amber's statement purely is important, because if the board member is sort of getting involved and trying to influence the making of that contract, that might lead to a different result.
Right. And what about a labor organization that would be advocating a position in front of the CalPERS board?
It would depend on whether or not the labor organization itself is considered a party to the proceeding or a participant. So the party would be the person, the individual or entity that either files an application or is the subject of a proceeding. And then a participant would be the person or entity who is not the party, but who actively supports or opposes a particular decision in a proceeding involving a license permit or other entitlement for use. And importantly, who has a financial interest in the decision. So I think, and then also a person actively supports or opposes a particular decision if they lobby in person, the officers or employees of the agency to influence the decision. And so I think with regard to the labor organization, the question would be whether or not they're a participant, and that would turn on whether or not they themselves have a financial interest in the decision.
As a organization as opposed to a body that represents members that have a stake in the outcome. Is that correct?
Yeah, I mean, that might be one of those scenarios where we would be doing a little bit more analysis as to the particular contractor vote under decision to determine if it would be have a financial interest for the labor organization, as opposed to the members themselves. I guess my thought here is the answer is it could be. I think that like with a lot of the Political Reform Act conflict of interest questions, it's a very fact intensive analysis. So I would say that labor organization possibly could be considered a participant, but we would probably want to look at the particular facts in a given case.
All right. Thank you for now.
Ms. Oliveris? Oh, she'll be back in 5 minutes. Okay. I have a question then, similar to Ms. Knowlton's question. We have a robust delegated authority model at CalPERS, where the delegation has been made for staff to make decisions on various contracts, but then they report out at subsequent dates what actions they've taken on those various contracts. Does that constitute any problem with the member then becoming aware of that transaction? Because it has already occurred, but it's still coming before the board for information.
If it's coming before the board for information only, then I don't think that we're looking at an 84308 issue. Yeah, again, it's voting on a matter on the campaign donor who's now a participant or party in a proceeding before the board. But if it's a staff report out after the fact, then the 84308 provisions aren't implicated.
Okay, I think that's all the questions so far.
Okay, next slide. So we covered this before we went back to a few questions. So we can fast forward to the next slide, please. So this is changing gears a little bit. Here we're talking about a different type of conflict of interest framework that is not statutory. So far, everything that we've talked about has been found in different provisions of the government code and other statutory provisions. Outside of that is the common law conflict of interest. So this is where the court has found a conflict of interest. And what's important about this and distinct about this is that unlike a 1090 and unlike a PRA financial interest or conflict rather, a common law conflict of interest is not purely economic. It can also be personal in nature. So this is somewhat rarely invoked, but it is out there. And so we wanted to make sure you all were up on this as well. The Attorney General opinion in in Ray Torres was a situation where a board member of a redevelopment agency had an adult son who was applying for a commercial loan from the redevelopment agency. Not only was he her adult son, he shared an apartment with her, but he was not financially dependent on her. And the question was whether or not this presented a conflict of interest under either the Political Reform Act 1090 or common law. And here the Attorney General determined that even though there's no real financial interest between a parent and their adult non-dependent child, the AG found, it would be really impossible for her to not want to see her son succeed, and have the agency, the redevelopment agency, grant the loan to him, to his corporation. And so there, even though there was a common law conflict of interest, the Attorney General also determined that in that case, disqualification was also allowed. So again, unlike 1090, but like Political Reform Act, if you have a common law conflict of interest, you can disqualify yourself from any involvement in the decision. And then the rest of your agency will be able to act. Next slide, please. So this final topic that we're talking about looks at what happens right when you're getting ready to leave office, and then what happens after you leave office. So the first rule here is considered a ban on influencing prospective employment. Again, now we're back in the Political Reform Act. So the basic rule here is that public officials may not make or participate in making or use their official positions to influence the making of a government decision that is directly related to any person with whom they are negotiating or have an arrangement concerning future employment. So that the idea here being that as long as you're still working for your government agency, you certainly don't want to use that position to make a governmental decision that will have a positive impact on a third party, private business that is considering hiring you, or that you would like to hire you. Next slide, please. Beyond that, the remainder of these post-employment provisions, the best way to think about them are cooling off periods. So these are statutorily set time periods after which you've left public office that you may not be paid by a third party to come back and influence your former agency on particular matters. And each one has a different time frame. There are 3 under the Political Reform Act that apply specifically to former members of CalPERS. And the 2 things that each of these have in common is that they only apply once you permanently left, and they apply if you're being compensated by another person to do this influencing or interfacing with the former agency, here CalPERS. The first one is a 4-year ban, and this is a sort of broad ban on coming back and influencing CalPERS for the purpose of influencing legislative or administrative action, and this is delineated in the last bullet point. Any discretionary action involving the issuance, amendment, awarding, or revocation of a permit, license, grant, or contract, or the sale or purchase of goods or property. Next slide, please. And these other 2, again, what they have in common is that they apply once you've left office, and prohibits receiving compensation from another entity for influencing CalPERS. The second one is a 2-year ban. The first one was a 4-year ban. The second one prohibits you from going back to CalPERS for the purpose of influencing obtaining a contract or a contract amendment. And then the 10-year ban, this prohibits former CalPERS board members and covered staff from serving as a placement agent in connection with investment before, and in this case, the prohibition applies to both CalPERS or CalSTRS. And again, this is a 10-year ban. Next slide, please. And finally, there is in the Public Retirement and Pension Plan law, its own conflict of interest post-employment rule that applies, very similar to the ones in the Political Reform Act. Here, again, it's a 2-year waiting period on post-governmental activities by former California Public Retirement System board members and executive officers. And again, very similar to the Political Reform Act, it prohibits former board members and staff from going back to CalPERS and seeking to influence legislative or administrative action or contract decisions for a period of 2 years. And next slide. And are there any questions on these topics?
Okay, I'm looking. I don't see any additional questions from board members. No, I don't see any additional. Oh, wait, Ms. Oliveris.
Thank you, President Jones. Would it be possible to get this in some type of grid format as like a one-page reference chart?
Which part are you referring to? The post-employment part?
Yes.
Yeah, that's certainly doable.
Thank you.
Okay, well, look like they're.
We also have a stock memo from the compliance office on these prohibitions that we can circulate.
Okay, that'll be good, Matt. Yeah. Okay. Okay, so I see no additional questions from board members, so I'll ask Mr. Fox whether or not there are any questions from the public or comments from the public on this matter.
Yes, Mr. President, there are no callers.
Oh, okay. Yeah, there are no callers. Okay, thank you very much. Okay, well, Ms. Dunnan and Ashley, was it Ashley, I think? And
Amber Maltby, yes.
Yeah, Maltby, right.
Maltby,
Thank
right.
you for a very comprehensive presentation. It's a lot of things to think about and to consider as we move forward and ensuring ourselves that we're in compliance with all of the necessary conflict of interest and reporting requirements of the FPPC. So thank you for a very comprehensive presentation.
Well, thank you for having us. We appreciate it. And we would urge you not to pick your way through this minefield. If you have questions, be sure to ask your legal counsel office before you get on the dais, because a lot of them do require some factual analysis and additional questioning before they can answer you. So
yeah, and there were a few follow-up items that you will provide to the full board, right?
Yes, so, I'll coordinate with your chief counsel on that.
Okay, we'll look forward to it. So with that, then we want to thank you again for that presentation. And so I guess, Mr. Jacobs, we'll give you 10 minutes to elevate the next presenters to the dais, if you will. So why don't we, what time is it now? Let's say 5 o'clock. Enough time, Mr. Jacobs, to elevate the people up? Okay.
That's fine.
Let's reconvene at 5 o'clock.
Thank you all.